Good morning. I hereby call to order this first meeting of the Pennsylvania Public Utility Commission for the year 2024. Welcome to everyone here in the room with us today, and those of you watching on the live stream. Please stand now for the Pledge of Allegiance. At today's meeting, which is open to the public, the Commission will act on various matters. There is no opportunity for the public to address the Commission at this public meeting. The public meeting motions, statements, and video will be available on the Commission's website later today. The first matter on this morning's agenda are the minutes of the meeting of December 7th, 2023. I recognize Commissioner Zerfas as the editor of the minutes. Commissioner Zerfas.
Thank you, Mr. Chairman. I have reviewed the minutes of the December 7, 2023 public meeting and move that they be approved as submitted, please.
And before we take a vote here, I do want to recognize that Commissioner Coleman is joining us telephonically today. So we've heard the motion by Commissioner. Chairman. Thank you, Commissioner Coleman. We've heard the motion by Commissioner Zerfas. Is there a second?
Second.
Seconded by Commissioner Yonora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary, we are ready for your presentation.
Good morning, Mr. Chairman. Good morning, Commissioners, and Happy New Year. Your various bureaus and offices have prepared the following agenda items for your consideration. Therefore, let us begin on page 1 with matters presented by Director Monahan and the Bureau of Audits. It is recommended that the Commission adopt in an omnibus motion both items on page 1, beginning with the audit report on purchased gas costs for the National Fuel Gas Distribution Corporation, and continuing the omnibus to include and end with the single item on page 2, the audit report on the distribution system improvement charge for the Columbia Water Company, and release all audit reports to the public.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfas. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Turning to page 3 in matters presented by Director Hafner and the Office of Special Assistants. It is recommended that the Commission adopt the proposed opinion and order in the formal complaint of Linda and Hubert Beck versus PPL Electric Utilities.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Second.
Motion made by Commissioner Yonora. We'll give John this one. Seconded by Commissioner Coleman. Any discussion?
Chairman, I do have a motion.
Vice Chair Barrow.
Please enter my motion in the record as though I read it in its entirety. This is a smart meter installation complaint, and I'm making a clarification on the application of the Supreme Court's precedent in PUC versus PUC. I agree the complainants failed to prove their complaint, but I move to clarify that our Supreme Court did not expressly conclude in PUC that the assertion of a constitutional right to refuse installation of a smart meter on the basis of bodily integrity was unfounded. Instead, the court denied aliquotter on the issue. Nevertheless, the Commonwealth Court in the same case did conclude as a matter of law that the record and legal argument in PUC failed to raise a viable claim of the violation of bodily integrity. The facts and legal arguments in the present case are on all fours with PUC, and therefore the Commonwealth Court's decision is binding on the Commission. Therefore, I move that the exceptions of the complainant at this docket are denied consistent with this motion, and the Office of Special Assistant shall prepare an opinion and order consistent with this motion. Thank you.
We've heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Zerfas. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Continuing on page 3, it is recommended that the commission adopt the proposed...
I'm sorry, we have to back up. We have to consider the matter as amended now. So that was the vote on the motion as amended. All those in favor, please say aye.
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 Aye. Those opposed, no. The ayes have it by a vote of 5-0.
Continuing on page 3, it is recommended that the commission adopt the proposed opinion and order in the formal complaint of Judith Hendon versus the Metropolitan Edison Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Vice Chair Barrow. Any discussion?
Mr. Chairman, I have a motion.
Vice Chair Barrow.
This is the same motion as the previous motion I just read. Smart meter installation, application of POVAC versus PUC. Please enter this motion into the record as though I read it in its entirety. I will not. I will read the moving paragraphs, and they are, I move that the exceptions of the complainant at this docket are denied consistent with this motion, and that the Office of Special Assistant shall prepare an opinion and order consistent with this motion. Thanks.
We heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. Motion passes by a vote of 5-0. On the matter as amended by the motion, is there any further discussion? I do have a statement, a conflict statement. Before joining my staff as legal counsel, Joel Cheskis was employed in the Commission's Office of Administrative Law Judge and worked on this case. Please note, he has not advised me in this matter. On the matter as amended, any further discussion? Any objection to taking the previous roll call? Hearing none, matter passes as amended by a motion by a vote of 5-0. Madam Assistant Secretary.
Turning to page 5, it is recommended that the commission adopt the proposed... Wait, I'm sorry. I'm missing page 4. Okay, turning to page 4, it should be noted that the single item on page 4, the formal complaint of Charles and Sylvia Bolt versus the Metropolitan Edison Company, has been postponed until the public meeting of February 1st, 2024. Turning to page 5, it is recommended that the commission adopt the proposed opinion and order regarding the petition for reconsideration in the formal complaint of Cunningham Township versus Sanitary Sewer Authority of the Borough of Shikshini.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Yanora, seconded by Commissioner Zerfus. Any discussion? I do have a conflict statement in this matter. Before joining my staff as legal counsel, Stephanie Weimer was employed in the Commission's Bureau of Investigations and Enforcement and worked on this case. Please note she has not advised me in this matter. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Continuing on page 5, it should be noted that the formal complaint of Rob Naborn and Cynthia Cronco versus the Pico Energy Company and Direct Energy Services, LLC has been postponed until the public meeting of February 1st, 2024. Turning to page 6, it is recommended that the Commission adopt the proposed opinion and order regarding the various petitions filed in response to the Commission's order on the proposed rate increase by the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Turning to page 7, it is recommended that the Commission adopt the proposed opinion and order in the informal investigation by the PUC Bureau of Investigation and Enforcement versus PPL Electric Utilities.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chairman, I have a conflict statement.
Vice Chair Barrow.
Prior to joining my staff, Kayla Rost was employed in I&E, and she has not worked on this matter.
Thank you. Any further discussion? I do have a statement on this matter. I ask that my statement be entered into the record as though I read it in its entirety. Today, the Commission issues for public comment the settlement between the Commission's Bureau of Investigation and Enforcement and PPL Electric Utilities Corporation arising from billing and related issues that occurred for PPL's customers from December 2022 through May 2023. Today's order directs that the settlement be published in the Pennsylvania Bulletin and gives those interested in filing comments 25 days from the date of publication to do so. My initial review of this case reveals a large public interest in this matter. It appears this case involves significant issues that may have affected many customers. I write today to emphasize that now is the time for those interested to submit comments for the Commission to consider as it reviews the settlement. I strongly encourage the public to avail themselves of this opportunity. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Continuing on page 7, it is recommended that the Commission adopt in an omnibus motion the tariff supplement proposed by the Columbia Water Company, and continuing the omnibus to include both items on page 8, and including and ending the omnibus at the top of page 9 with the request filed by UGI Electric and petition for reconsideration of staff action.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Yanora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Continuing on page 9, it is recommended that the Commission adopt the proposed opinion and order in the petition for reconsideration filed by Emerald Bioenergy, LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chairman, I have another conflict statement for
Vice Chair
Kayla
Barrow.
Rost. She did not advise me on this matter.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Turning to page 10 and matters presented by Director Diskin and the Bureau of Technical Utility Services. It is recommended that the Commission adopt in an omnibus motion both items on page 10, beginning with the cancellation of licenses for certain electric generation suppliers, and continuing the omnibus to include both items on page 11, both items on page 12, both items on page 13, and including and ending the omnibus at the top of page 14 with the 2024 price change opportunity filed by Verizon North, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Yanora, seconded by Vice Chair Barrow. Any discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Continuing on page 14, it is recommended that the Commission adopt the proposed order in the suspension of the proposed rate increase filed by the Peoples Natural Gas Company, LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion? I do have a statement on this matter. I ask my statement be entered into the record as though I read it in its entirety. Today, the Commission suspends by operation of law until September 27th, 2024, the distribution tariff and supplier tariff filings made by People's Natural Gas, LLC, proposing changes in rates, rules, and regulations calculated to produce $156 million in additional revenues, or an increase of approximately 18.7%. As usual, this action allows for the investigation of the lawfulness, justfulness, and reasonableness of people's filings by sending the matter to the Office of Administrative Law Judge for the prompt scheduling of hearings that, as may be necessary, culminating in the issuance of a recommended decision. I write today to commend our staff for expeditiously putting this matter on the public meeting agenda. The filing was made on December 29th, 2023, and the Office of Consumer Advocate filed a formal complaint on January 5th, 2024. This matter could have been suspended for investigation at our public meetings of February 1st, 2024, or February 22nd, 2024. Yet, by putting this matter on today's public meeting agenda, the case will be sent to the Office of Administrative Law Judge earlier. A pre-hearing conference can be scheduled earlier, and the interested parties can begin their review of the filing earlier. In this instance, all this can happen up to 1 month earlier, thereby providing important additional time for the parties to conduct their review of the filing in the beginning of the proceeding, and the Commission to conduct its review of the results of the litigation at the end of the proceeding. Filings such as these can have significant impact on the public interest, and the additional time for review allowed by having this matter suspended at the earliest opportunity will help ensure that the resulting rates, rules, and regulations are just and reasonable and in the public interest. The staff's efforts in this regard are appreciated, and I hope that this is the process moving forward on these cases. Any further discussion?
Mr. Chair, I'd like to associate myself with your statement.
Any further discussion?
Mr. Chairman, I also would like to associate myself with your comments. They must have been really good, right?
Thank you. I was working on them all night. Any further discussion? Thank you. Thank you. On the matter, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Turning to page 15, it is recommended that the Commission adopt in an omnibus motion both items on page 15, beginning with the security certificate filed by UGI Electric and including and ending the omnibus motion on page 16 with the cancellation of certificates of public convenience of certain motor carriers.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Second.
Motion made by Commissioner Zerfus, seconded by Commissioner Yanora. Any discussion?
Mr. Chairman, the matter at the bottom of page 15, quarterly earnings report, I will abstain.
Okay. So we'll keep them all together, and then I'll announce 2 separate votes.
Okay.
Okay? Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote. So the 2 matters, the first matter on page 15 and the first matter on page 16, the ayes have it by a vote of 5-0. The second matter on page 15, the ayes have it by a vote of 4-0, noting the abstention of Vice Chair Barrow. Madam Assistant Secretary.
Turning to page 17, it is recommended by Chief Counsel Screven and the Law Bureau that the Commission adopt the proposed opinion and order regarding the Commission's eligible customer list order and the petition filed by the Duquesne Light Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Please enter my statement in the record as though I read it in its entirety. This statement contains my thoughts regarding the proper application of the DUIC standard. I'm going to skip over the majority of the statement. Please read it at your convenience. But I do want to say that imposing the DUIC standard in a petition for clarification is not appropriate. It creates an impossible burden because the petitioner is not asking the commission to reevaluate or an order or take other affirmative action. What they're seeking is an explanation or an interpretation. It would be illogical to hold a petition for clarification to the DUIC standard and require a presentation of new and novel arguments. They're seeking clarification. So they're not seeking a change or a modification or to otherwise disturb the commission's order. So those are my thoughts on the application of DUIC to a petition for clarification. Thank you.
Thank you, Vice Chair Barrow. Any further discussion? I would like to associate myself with the Vice Chair's remarks.
Thank you.
All those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Turning to page 18 and matters presented by Chief A.L.J. Rainey and the Office of Administrative Law Judge. It is recommended that the Commission adopt the initial decision of A.L.J. Vero in the formal complaint of James J. Collins versus the Metropolitan Edison Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfis, seconded by Commissioner Coleman. Any discussion?
Chairman, I have a verbal statement.
Commissioner Barrow.
This is a complaint by Mr. Collins alleging that a power surge caused by Met-Ed created dangerous conditions and damaged his property. For some unknown reason, Mr. Collins did not appear at the hearing to prosecute his complaint, and as these things often go, the case was dismissed with prejudice. You've heard me speak before. I'm not a fan of the Commission's process when it comes to dismissing cases with prejudice. This case is case in point. He's alleging a problem with the power serving his house. These kind of conditions happen over time usually. It's not usually once and done. He didn't show up to prosecute this complaint, but for whatever reason, however, might have been work, might have been something else. If it is a continuing problem, he should not be barred from returning to the Commission with his complaint. So I do not agree with dismissing this type of complaint with prejudice. Another thing I wanted to point out is that Section 5.245 of our regulations, which we rely on for these dismissals with prejudice, I think is being misapplied. In this case, he didn't show, no facts were entered into the record. A decision was not made on the substance of the complaint. For him to come back and try to reopen this, he is not trying to overturn findings that were made by the judge on the substance of the complaint. So it's just a different interpretation of our process that I wanted to state. Thank you.
Thank you. Any further discussion? I do have a statement in this matter. I ask that my statement be entered into the record as though I read it in its entirety. The initial decision in this matter dismisses the complaint with prejudice because the complaint failed to appear at the scheduled hearing and carry his burden of proof. The complaint did not indicate why his failure to appear at the hearing was unavoidable or otherwise notify the Commission to explain his absence. In a separate matter, the Commission recently entered a notice of proposed rulemaking to amend the Commission's procedural regulations at chapters 1, 3, and 5. The NOPR solicits comments on the current practice of dismissing the complaints of pro se litigants with prejudice when a complainant fails to appear. The NOPR seeks to address the Commission's current regulations at Section 5.425 that do not permit the matter to be reopened at a hearing, after a hearing, if a party fails to be represented at a scheduled hearing. Since a pro se litigant has not secured counsel, the NOPR seeks comment on clarifying when a complaint filed by a pro se litigant can be dismissed with prejudice. I look forward to receiving comments on this topic. In the meantime, the Commission's existing regulations as Section 5.245 apply to this case unless and until they are modified. The facts in this proceeding differ from previous cases that the Commission has considered involving a number of pro se complainants whose complaints were dismissed with prejudice upon their failure to appear at scheduled evidentiary hearings. Those complainants were provided with an additional 20 days to file a written request for another evidentiary hearing. In those matters, there was a belief that due process rights of these pro se complainants were violated because the complainants did not affirmatively agree to receive documents from the Commission by email. Here, however, there is no question about the service of the complainant elected to enroll in the Commission's e-filing subscription service or e-service, which provided the required consent to receive documents served by electronic mail. Accordingly, dismissal of the ID with prejudice is appropriate in this instance, as the complainant was properly served with the Commission's documents, including the hearing notice. And the dismissal is based on the existing regulations, which have not been modified. Any further discussion?
Chairman,
Vice Chair.
thanks for the reminder about the rulemaking. That's a good reminder for the public. Yes, but one more thing, I always worry with power surges and when property is harmed. So I would like to ask the Bureau of Technical Utility Services to examine the facts around this power surge if they could. Thank you.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Continuing on page 18, it is recommended that the Commission adopt the recommended decision of ALJ Chiodo in the rate increase proposal of the Pittsburgh Water and Sewer Authority.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chairman,
Vice Chair.
please enter my statement into the record as though I read it in its entirety. Before us for consideration is the recommended decision approving the joint petition for settlement of all issues in the Pittsburgh Water and Sewer Authority's rate case. The settlement, among other things, highlights PWSA's agreement to participate in collaborative meetings related to stormwater and enhancements to its low-income assistance programs, customer service, and quality of service. The company agreed that within 30 days, its care team will contact the city and the Allegheny Department of Human Services to identify potential mechanisms for cross-enrollment of low-income customers through other municipal offices serving the city or through coordination with programs or services administered by Allegheny Department of Human Services. I commend these organizations for agreeing to work together to provide PWSA's low-income customers with the assistance they need to pay their utility bills. In order to ensure that all of PWSA's customers are properly educated on these programs, I encourage a focus on a robust and enhanced customer education program for the water and wastewater utilities as well. In addition, I encourage PWSA to track any potentially negative issues related to cross-enrollment of its low-income customers so that those issues may be addressed in a timely and efficient manner. Thank you.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Turning to page 19, it is recommended that the Commission adopt the initial decision of ALJ Long in the formal complaint of Kimberly Abel versus the West Penn Power Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Yanora. Any discussion?
Mr. Chairman,
You've been busy, Vice Chair Barrow.
of course it's me. Please enter my statement into the record as though I read it in its entirety. And it's a long one. This one, this is a inability to pay complaint. And Mrs. Abel, who's been a customer since 2009, has an extraordinarily large arrearage, $23,633.90. She came to the commission because she'd received a termination notice, and she asked for a payment arrangement, one that wasn't going to change monthly, and noted that her husband is on oxygen, so she needs electric service. There was a hearing convened in August of last year. She did not appear, and West Penn presented evidence at the hearing indicating the following. So, been a customer since 2009. By 2012, she filed a medical certificate. The account balance at that point was $7,157. By 2013, when she presented another medical certificate, the balance was slightly lower, $7,043. She presented 3 other med-certs, which were denied by the company. And moving ahead to 2016, she was enrolled in the CAP program. So it's 7 years later, and she's enrolled in the CAP program. At that point, the balance is $14,587. She was removed from the program in 2018. The balance was considerably lower than $14,000. It was $8,509. She was removed from that program because she failed to recertify her eligibility. In 2019, the account balance was $12,384. Her monthly income at that point was $788 per month. She was put on a payment arrangement by the company, budget bill of $114 plus $1,032 for the arrearage monthly plus EGS charges. She, of course, defaulted on that payment arrangement. COVID came, we had our emergency order, and the balance grew to $19,585. And during COVID, as happened with a lot of people, her monthly income went down to $362. She was placed on a payment arrangement by our Bureau of Consumer Services. By the time we got involved there, her monthly income had gone up just to $1,444. And the payment arrangement that under Chapter 14 we put her on was budget bill of $114 plus $328 plus EGS charges. So I'm going on at length about this because when we see an arrearage like this that is north of $20,000, north of $30,000, I think we've seen before, it's really easy to say, who screwed up? What happened? But I'm also aware that on days like this, weeks like this, people need electricity to heat their homes. And so I get really concerned when I see a case like this, which I think probably could have been avoided. I don't like telling a utility to ever terminate someone, but frankly, termination probably should have happened a lot earlier. But the other thing the utility could have done is, back when this lady was making payments, and she actually was making some big payments over time, given what her income was, when they had an opportunity to put her on a payment arrangement, it never should have been for $1,000 plus. It was like $1,146 a month. I don't understand why that happened, especially at a point when she was paying down the arrearage. So I see a missed opportunity there, but I also see a missed opportunity in not nipping this in the bud earlier on. There is no way someone with her income is ever going to be able to dig out from under this bill. There's a fine line between asking the utility to apply flexibility to consumers in unfortunate circumstances so that they can receive payment, and asking the utility to terminate service when it becomes unmanageable. There's always complexity in an individual case that needs to be taken into consideration when bills start stacking up like this. I ask the utilities to really pay attention. Every customer is not going to be the same. This lady, she made 8 substantial payments in 2021 during really challenging circumstances. The utilities have way more discretion than the commission. We're locked in with Chapter 14 as it is currently written. There's but so much we can do, but the utilities can do more, and I'm just asking and pleading that y'all do more and do it early. Be practical in what you ask for, and understand that all customers are not the same. We have some customers who they can't pay, they won't pay, they don't pay. But then we've got customers who try to pay and have some unfortunate circumstances going on. So just use a little bit of discretion. Thank you.
Thank you for your thoughtful review and comments on the matter. Any further comments?
Mr. Chairman? Mr. Chairman, I just have a verbal statement. The case before us today has a very unfortunate set of circumstances. I've been thinking about, I thought about this case when I went to bed last night, when I woke up this morning, when I was driving in, and as I'm sitting here. I will begrudgingly be voting yes for this matter today because I'm trying to strike that balance. So even though we have this very unfortunate set of circumstances where we have this like ungodly arrearage that's over $23,000, I can't ignore the facts that are before us where we have missed payments, a spotty payment arrangement, even though it seems as though Ms. Abel has tried her best. We've got some processes that weren't fulfilled. And I don't pass judgment on Ms. Abel. I think she was doing everything that she could. But again, I'm trying to find a way to strike that balance. And honestly, when I go to bed tonight, I'll wonder if my yes vote is the right vote anyway. But the system seems flawed. To piggyback a little bit on the Vice Chair's comments, the system seems flawed. I don't want to see cases like this anymore. We should be proactively helping people on the front end instead of having these cases on the back end where we're determining what to do when we're already here and with these unfortunate set of circumstances. The system should be helping consumers before we get here. So this is an opportunity as we talk about the reauthorization of Chapter 14, how we, the collective we, can do better for Pennsylvania consumers. We, collective we, should be thinking about consumer-focused amendments when we're talking about the reauthorization here to try to get at that proactive nature, to try to nip this in the bud, as the Vice Chair said, so we're not in this position here. So again, I can't ignore the facts that are in front of me today. I will be a yes vote. I don't like it. I don't love it. But we need to do better collectively going forward. And if these cases keep coming towards me or coming in front of us, I don't know if my vote will always be a yes vote. I might be changing my vote going forward if these high arrearages keep coming to us. $23,000 or more, I don't know who in this room could dig out from $23,000. And I certainly couldn't, and I recognize that I sit in a place of privilege more so than others. So I will be a yes. I think we need to do better, and I hope we take that opportunity when we're talking about Chapter 14 to do that, but do it together. Thank you very much.
Thank you for your comments. Any further discussion?
Chairman, this is
Sorry.
Paul. I do have a couple of thoughts.
Commissioner Coleman.
Thank you. I'm reminded as we have these cases coming before us of my former colleague there, Commissioner Sweet, that used to refer to these as the worst of the worst. These are people that are in desperate situations that have, health issues, financial issues, and in other types of issues. And it is truly unfortunate that here we are at almost what appears to be the end of the line for Ms. Abel. And that unfortunately this is a tale that has been going on over the past 15 years. I agree with my colleagues that I don't wish to see these kinds of cases continue to come before us. But I think that we need to look at the record here and realize that the current payment arrangements and rules and regulations that are found in Chapter 14 of the Public Utility Code and in Chapter 56 of the Commission's regulations are precisely what allowed Ms. Abel to maintain her service and to amass the $23,000 debt over the past 15 years. It's these current rules and regulations that will continue to protect Ms. Abel from termination of electric service through the winter moratorium and perhaps beyond. So I don't believe this is the end of the story with Ms. Abel. And she has not yet exhausted all of her administrative remedies and her medical certificates. I think that there's work for all of us here. And I appreciate that perhaps the company could have done something earlier than now in this process to avoid this from happening. What I have asked this commission over the years is to say, what specifically is it that we, as this commission, would find acceptable for the company to be able to do in these kinds of situations? That had the company terminated Ms. Abel at an earlier point in time, I would suspect the conversation would be admonishing the company because there are still additional remedies available for Ms. Abel in Chapter 14. So I think there needs to be some clarity as to what is going to be the acceptable path for the utility with customers that get arrearages. We do ask them to provide us those arrearage numbers for any customer over $10,000. So we have that information, but yet we have not provided, I believe, a clear path for the companies to clearly understand what this commission would see as an acceptable remedy going forward to avoid these kinds of arrearages. Perhaps most important for me is I'm concerned about, as Commissioner Zerfas had mentioned, I'm concerned about those who don't have the privilege that many of us do to pay their bills and that are making a very difficult decision to pay a utility bill over other household expenses. This bill, most likely for Ms. Abel, is going to be socialized over those customers. And they are the ones that I'm concerned about the most. We keep raising the bar on the low-income customers, those who, a majority of whom, are paying their utility bills. But by us getting to this particular point with Ms. Abel and a $23,000 balance, again, most likely this amount or greater is going to be socialized over all of West Penn's customers, and I find that to be an unfortunate conclusion here. Finally, what I would suggest is an encouragement to Ms. Abel, and that is that she carefully review her energy supply contracts, as she has been paying charge rates that are higher than what the price to compare is in the West Penn service territory for many billing cycles. So again, I hope that we as a commission can find a better path forward here and look forward to those conversations. Thank you.
Thank you for your comments as well, Commissioner. Any further discussion? Vice Chair Barrow.
Yes, thank you. I hear you, Commissioner Coleman. I want to make a couple more points. I don't think I would have ever admonished the company for terminating this customer early on. Of course not when she had a medical certificate. My admonishment is in that this customer was clearly eligible for a CAP program to get at a lower rate. She wasn't put on it until she was really in trouble. I don't know what kind of outreach happened there. I do not know the answer to that, so I might be wrong. But there were opportunities over the years, since 2009, as the arrearage grew for more to be done. I hope that as the legislature debates the reauthorization of Chapter 14, as Commissioner Zerfis said, we can all work together to come up with some common sense solutions to help folks out a bit more. Thankfully, there is no more CAP shopping in PA, so customers like this will not end up on a high EGS rate anymore. I know that that contributed to this astronomical arrearage, so that was I am really happy that that is over. And finally, there's nothing that this commission can do for this customer at this point. So I'm okay with the recommendation to deny the complaint. However, there is a discussion about abusive process and barring this customer from ever filing with the commission again until this arrearage is paid off. That I completely disagree with. Thank you.
Thank you. Any further discussion?
Oh, Mr. Chairman, one more thing, please.
Commissioner Zerfis, I'm going to stop asking that question.
Just, this will literally take a couple seconds, but, I just wanted to piggyback on a comment that Commissioner Coleman made, and I would agree that with the concerns of socializing costs of unpaid balances for everyone else, I would just also add and remind folks that there are other consequences and costs that are socialized when we're talking about these kinds of cases, where someone like a Ms. Abel or others like her or in worse off circumstances, we will also be socializing the cost of homelessness or bankruptcy if we don't help these people. So again, adding to my earlier comments about trying to figure out a proactive way on the front end to help folks so we're not here on the back end trying to figure out what to do with these unpaid balances. There are socialized costs related to the utility, related to homelessness, related to bankruptcy, and others. So lots of important conversations that we need to have in the coming weeks and months, so thank you.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Continuing
Mr.
on page
Chairman.
19.
Sorry, I am a partial dissent.
Okay.
Okay, but I will vote aye, but I am a partial dissent.
Okay. That matter passes by a vote of 5-0, noting that Vice Chair Barrow is a partial dissent. Madam Assistant Secretary.
Continuing on page 19, it is recommended that the Commission adopt the recommended decision of ALJ Heap in the application of Toa-Menson Township.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfis, seconded by Commissioner Yanora. Any discussion?
Of course.
Vice Chair Barrow.
Please enter my statement in the record as though I read it in its entirety. Before us for consideration is the recommended decision of ALJ Heap. We have approving a settlement between Toa-Menson Township and the Office of Consumer Advocate. This is in regards to the application for a certificate of public convenience for Towamencin Township for their wastewater service to customers in Worcester Township, Montgomery County. I agree that the CPC should be granted, but I need to point out that this system, it provides service to approximately 8,000 customers, including 310 customers outside of their boundaries. They also provide service to some bulk customers in the county. And in their application, in support of the application, they listed a number of things. And all of these things point to this company being fairly well run. They've got $5.7 million in available funds in the sewer account dedicated to wastewater service. They have a Standard & Poor credit rating, AA stable. It's a financially sound municipality that can support ongoing operation and investment commitments. It has provided wastewater service for over 50 years without financial issue, employs professionals with expertise in all areas of wastewater utility operations, has provided service for the 50 years and demonstrated adequate fitness in doing so. The settlement also references a pending matter before the commission, and that is Pennsylvania American's request for approval to acquire the wastewater system that we're talking about under Section 1329 of the code. The settling parties note that this settlement in no way implies that the Section 1329 application should be approved or disapproved, and but also indicates that this application is connected to and predicates the filing of that pending 1329. And I shouldn't say pending because the application for the 1329 has not been perfected as yet, as far as I can tell. Now, in that application, those parties agreed on a purchase price of $104 million. The appraised value for the system, we've got the appraisals in. Gannett Fleming says 110, Scott Madden 97.5. I think we ended up at 104. And on the other hand, I'm looking at the depreciated original cost of this system is valued at $11.4 million. Original cost was $38.9 million, depreciation 27.5. So it would have been remiss of me not to point that out ahead of whatever is coming at us in that 1329 application. I have no concerns with the instant application. Granting the certificate of public convenience will benefit the customers, but I did need to note what I see coming our way, especially because it was mentioned in the instant application. Thank you.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
Turning to page 20, it is recommended that the Commission adopt the initial decision of ALJ Arnold in the formal complaint of Brian Holler versus the Pennsylvania Electric Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Mr. Chairman?
Vice Chair Barrow.
This is just a verbal statement, and I won't go into it. It's the same issue I raised earlier about the dismissals with prejudice. Thank you.
Any further discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it by a vote of 5-0. Madam Assistant Secretary.
And finally, on page 20, it is recommended that the Commission adopt the initial decision of ALJ Brady in the formal complaint of Wanda Walker versus the PECO Energy Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Second.
Motion made by Commissioner Zerfus, seconded by Vice Chair Barrow. Any discussion?
Mr. Chairman,
Vice Chair Barrow.
I have a statement. Please enter my statement into the record as though I read it in its entirety. This is also an inability to pay case. Ms. Walker filed a formal complaint stating that PECO is threatening to terminate service, that there are incorrect charges on her bill, and seeking credits on her account. PECO filed an answer stating that the claims raised in this complaint related to payments in 2018, already decided in a 2020 formal complaint proceeding. Actually, that was concluded in 2023. And that the instant complaint should be denied on the grounds of res judicata. The ALJ here dismissed this formal complaint with prejudice, stating that the current formal complaint reasserts the same allegations, arguments, and requests for relief as the 2020 formal complaint. In rendering that decision, the ALJ ignored PECO's res judicata argument and instead based the legal analysis on Section 316 of the Public Utility Code. I believe the ALJ erred in dismissing PECO's defensive claim. Rather, I believe that the judge should have addressed PECO's arguments and applied the doctrine of res judicata. While I agree that the doctrine of res judicata is met and that the instant formal complaint should be dismissed with prejudice, I disagree with the application of Section 316 to this matter. Thank you.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it by a vote of 5-0.
Mr. Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you. Before we adjourn today's meeting, my fellow commissioners and I would like to recognize the retirement of Andy Teresiani from our Bureau of Investigation and Enforcement, or I&E. Andy is the chief of the Motor Carrier Enforcement Division in the Bureau of Investigation and Enforcement. Chief Teresiani will be retiring on Friday, January 26th, wrapping up a 51-and-a-half-year career in law enforcement. While serving in the United States Marine Corps 4th Division Air Wing Reserve, Chief Teresiani began his law enforcement career as an officer in the Wilkes-Barre Township Police Department, where he attained the rank of sergeant. Also, during this period, Chief Teresiani earned an associate's degree in criminal justice from the Luzerne County Community College and a bachelor's degree in criminal justice from King's College. In addition, he earned 18 credits towards his master's in criminal justice from Marywood College. Andy joined the Public Utility Commission in August of 1988 as a public utility enforcement officer. His PUC career is noteworthy in that he took advantage of every opportunity to develop and advance. A review of his PUC career shows a steady progression from officer to supervisor to regional manager to his current role as chief. Throughout this progression, Chief Teresiani never forgot how he got there. An apt description of Chief Teresiani is that he is a lifelong learner. In addition to his degrees identified above, he has 34 different trainings and certifications listed on his resume. From his days as a road dog to his role as the chief, Andy has constantly strived to move the division forward. Whether it is a safety fitness review, bus inspection, or sting operation, Chief Teresiani consistently sought out ways to be more efficient and effective. He played an integral role in getting bus ramps included as equipment in the Motor Carrier Enforcement Division to allow for closer inspections compared to a walk-around. Professionalism within the division has always been a key point throughout Chief Turiziani's career. Every aspect of motor carrier enforcement includes a component of pride in how officers present themselves. The current uniform patch worn by all officers was designed by Chief Turiziani. Andy has indicated that he is looking forward to his free time. And by free time, I believe he means operating on his schedule, not a PUC schedule. Judging by his upcoming plans, there's not a lot of free time yet, though. Although a rest is well-deserved, the Chief's immediate plans are quite the opposite. In addition to spending time with Emily, his bride of 48 years, he's planning a trip to Disney World in April of 2024 with his daughters, son-in-law, and 2 grandchildren. His immediate plans include the Rocky Mountaineer training excursion with Emily in June of 2024. Andy, I would like to recognize your many years of service and thank you for the years you spent making this commission a better place. Please join me in congratulating Chief Andy Turiziani on a job well done. Andy, please come forward to say a few words now.
Thank you, Chairman, Vice Chairman, Commissioners. I credit my successes as chief based on the work ethics of my managers and administrator of programs in our division. All I could say is it's been the best job I've ever had. It's been the most rewarding, and thank you very much.
Andy, you're not done yet. I ask that you come forward to receive your retirement gift. Next, we turn to someone who needs no introduction, but who also asked no recognition today. And, you know, it speaks volumes as the type of person we're talking about here. He did not want to take anything away from the chief, so he asked to not be recognized, but we, you know, the role he's played here in this organization for so many years, we could not allow that to happen. So we'll only partially honor his wishes and just only say a few words, not a lot. Rick Kanaski, Director and Chief Prosecutor in our Bureau of Investigation Enforcement, is retiring from this commission at the end of the month. The commission appointed Rick to this important post in June 2016. He joined the PUC back in March 2001 as a prosecutor in the former Office of Trial Staff. And again, while we respect that Rick does not wish to be recognized today, we couldn't let him go. And again, for all the work he's done for this commission, we could not let him go without thanking him for his service and wishing him all the best of luck in his retirement. Thank you, Rick. Also, before we adjourn, I would like to take a moment to recognize the recent Martin Luther King Jr. holiday on Monday of this week, January 15th. The holiday is designated as a national day to remember and honor the civil rights leader's life and legacy. It is also the only federal holiday recognized as a National Day of Service, on which all Americans were encouraged to volunteer to improve their communities. This call is consistent with the National Association of Regulatory Utility Commissioners' annual observance of Martin Luther King Jr. Day that began with a resolution in 2008 designating the holiday as a day of utility service and as a day on, not a day off. People were challenged to find and engage in utility-related community service projects, find ways to help their neighbors, or promote and practice energy conservation. We're reminded that this is something that can be done on any day throughout the year in honor of Dr. King's legacy. Now, if there is no other business to come before the commission, is there any objections to adjourning the meeting today? Hearing none, we are adjourned.